Hi, Elise, are you there?
Can you see me? Yeah. Oh, can you hear me?
I can hear you, yes.
Okay. It said I was still muted, so I was like, oh no.
Elise, can I email you my PowerPoint presentation so you can broadcast it? I was thinking, what if like I get like client stuff popping on my computer and then, a whole bunch of
Yeah.
watching? Okay,
Yes, no problem at all. Go ahead and email it to me and I can get it pulled up.
okay. 1 second. Yeah, I sent it.
Okay, perfect.
Thank you, Elise.
Yeah, no problem. Good morning, everybody getting on. We will give it just a few more minutes to make sure that everybody is able to join. And let us know if you have any questions in the meantime. Good morning. Thank you all for joining us today. I am going to give it just a minute or two longer just to make sure that everybody is able to get in. If you guys have any questions in the meantime, just let us know and we will get started soon. Okay, we will go ahead and get started, and if people keep joining, I'll just make sure they're admitted in. I'm going to go ahead and pull up your PowerPoint, Kendra. Let's see here. Thank you all for joining us today. We have Kendra Hollingsworth with the Disability Rights Texas with us today. She's going to walk us through the special education process and hopefully answer some of your questions. I know that the special education process can be frustrating at times, and we often have questions about, what we can do in certain situations. So I think it'll be very helpful to speak with Kendra today and get a little bit of input. Let me go ahead and get her PowerPoint pulled open. Okay, let's see. Share my screen. Okay, can everybody see that? Yeah, okay. Okay, perfect. Well, Kendra, I will go ahead and let you take over, and I will go to the next slides, but if you're ready to go to the next slide and I haven't pressed it, just give me a little nudge, okay?
Okay, great. Hello, everyone.
Uh-oh, Kendra, I think you froze. Sorry, everyone, I think Kendra froze. So let me see if we can get her back.
Well, I've never been booted off Zoom before, so I guess there's a first time for everything. Great. Can you guys hear me okay? Yeah. Okay. So hello again. My name is Kendra Hollingsworth, and I am a senior education advocate with Disability Rights Texas. So I work on the education team. All of the cases I take are for kiddos who are in special education or 504. And then, of course, I also have some side projects that I do involving CPS, trying to get appropriate school investigations when teachers abuse children in school. So, next slide, please. So I want to go over some vocabulary to make this a little bit easier on everyone. We'd use a lot of acronyms in special education, and it can get a little, I think, frustrating at times. So a FAPE is a free, appropriate public education. LRE, least restrictive environment. IEP, individual education plan, and for us fun Texans, ARD, which is an admission review and dismissal committee. Next slide. Free appropriate public education is available to all students with disabilities aged 3 to 21 at public expense. Students must meet the definition of one or more of several enumerated disabilities and, by reason thereof, need special education and related services. Services must be based on students' unique individual needs and be designed to confer educational benefit. So that's a lot. Let's take that apart a little bit. One of the things sometimes people run into is 3 to 21. So we have early childhood, then we get into school, the public school system, and then after they, at 18, graduate or do not graduate, They have the ability to have an additional 4 years for transition services, which is 18 to 21. Actually, it goes until you're 22, the year that you turn 22. So you have that span of time as well. And during these years, you must qualify for special education. It's not necessarily given that you will. There are speaker. Oh, okay. Okay. All right. Thank you for telling. Oh, my microphone's doing something weird. Good to know. Okay. So typically reevaluations occur every 3 years, although they can occur sooner if you need them. But you have to show, in order to be in special education, you have to show an educational need for services. And you have to continue to meet the criteria under one of those categories. The services have to be based on the child's unique needs, their individual needs. So they can't give you a plan that they give to everybody else. Sometimes I hear that. Sometimes I hear, well, this kiddo has this behavior and we give this same plan to all kids with behaviors. That's not acceptable. It has to be a unique and individualized plan. And it also has to confer educational benefit. So if there's no educational benefit to the services that are being provided to you, then it shouldn't be a service. They should be providing a different type of service that does confer an educational benefit. Next slide. Initiating services. When you want to first get a services, the first step, whether you request it or a teacher requests it, usually not a teacher because often they're told not to, or someone on the school side, your first step is evaluations. So those evaluations will tell us if you qualify for special education, and then often they'll tell us what types of services that you need. Anyone can refer a child who's suspected of having a disability for special education. So it could be a parent, it could be a teacher, it could be a principal, it could be anybody. And when you make those requests, make them in writing, keep a copy for your records. In this day and age, email is a pretty good way to do that. If you don't have access to email, you can always mail a letter certified to the school. You can go up to the school with your letter and have them sign and date your copy. There's other old-fashioned ways to do it when you're making requests in writing, but email is a pretty good one these days. An ARD will be held sometimes before the initial ARD to discuss necessary evaluations. You might have an ARD to talk about what evaluations you want to do. Then the evaluations are done. And then you have another ARD to talk about if you qualified. Private evaluations are another thing I see a lot that crop up with parents. Maybe you go to the doctor and the doctor does a private evaluation that says your child has autism, or your child has whatever need. That's considered a private evaluation. It's not an educational evaluation typically. It's rare that a doctor would do an educational evaluation. So sometimes parents will pay for these private evaluations and think that will get them qualified for special ed, but they don't. The school district has to consider all relevant information. They have to consider your private evaluation, but they don't have to use it. Sometimes a private evaluation is a trigger for a special educational evaluation. So that's good. And sometimes if you already have special ed and you do a private evaluation, that information can be included in your IEP if the school chooses to accept it. So for parents out there that want to pay for private evaluations, just know that there is a chance that they may not be accepted. Next slide. Do I qualify? Hopefully that answer is yes, right? Because it's a lot of work to qualify. There are several categories under one of which you must qualify, and they all have different criteria. You only need one category to qualify. Sometimes you may qualify under multiple categories. That's possible. Sometimes parents will get upset because they want to qualify under one category and not another. I see that a lot when kiddos are maybe qualifying under emotional disturbance, and maybe the parent wants a different label, or maybe they get a label they don't really think is appropriate. You just need one label to qualify. If you believe that your services under that label aren't being met, it's not really about the label, it's about the individualized services at that point. Next slide. Eligibility. So you can have a disability and still not qualify for special education, and maybe not even 504, although that would be rarer. So do you have a disability that requires specialized instruction? That's kind of the big thing. You have to look in all areas in which the kid may be eligible, including like sometimes kiddos, maybe they're not eligible under emotional disturbance or ED, but they may qualify under OHI or other health impairment, which is basically a form that your doctor fills out saying you qualify. Eligibility does not determine services, and parents are meant to be equal participants in the IEP process. And if you're not, then that's a problem. The IEP team should reach consensus. I know sometimes the politics of the ARD committee does not always allow for that to be, and sometimes it can be quite contentious, but everyone should be in consensus by the end of the meeting. Next slide. So how can I have a disability but not get an IEP? I get that quite a lot. Do you need individualized instruction? And if not, a 504 plan may be the thing to do. 504 plans are designed to prevent discrimination, and those accommodations provide access for the disability. Sometimes you have to look at complexity issues when kiddos may not seem like they need individualized instruction, but they do. A big thing I see with that is grades. So if let's say a kiddo has good grades, or they have passing grades, even if they have C's, sometimes the school will say, well, they don't need anything, they don't need individualized instruction because they have C's. Well, maybe if they hadn't had individualized instruction, they could have A's or B's. They could be doing better. They could, maybe to get that C, they're doing 5 hours of tutoring a night. So you kind of have to look at the complexity of the issue and why they really are making those good grades, or why they seem to be making progress, and if it's not without burden. Next slide. The ARD process. I would just love it if all my ARD committees look like that, like they just sat there like across each other, looking like they were all cooperative. That would be great. Okay, next slide. Sorry. The ARD committee is supposed to meet at least once a year. You can meet more frequently if you need to, but you should meet at least once a year to revise and develop the IEP, particularly the goals. Your goals should change year to year, and if you're not meeting a goal year to year, that would be an issue. But you definitely shouldn't just be agreeing to the same goal year after year and never evaluating why that is. A parent can request more meetings than once a year. They can request more frequent meetings. Sometimes we have some issues in the state of Texas with parents requesting meetings and the school not wanting to allow it. And that would be what I would say ruins parent participation. Parent participation is required under the law. So if you're not allowing the parent to meet, that's a problem. But we have had some changes in Texas law that have put some barriers in place to parents who request more frequent meetings. It's not common, but there has been some things. Your ARD committee should consist of the parent, the student if it's appropriate. If it's not appropriate to bring your student into an ARD meeting, then you don't have to. Students are mostly in the ARD meetings when it comes to talking about transition services. That's usually the time when it's appropriate to have a student in the meeting. Times it might not be appropriate to have a student in the meeting, when they can't sit through a meeting, when their behavior might make them unable to be in a meeting, when you're going to talk about things in the meeting that maybe kiddos don't need to hear. If you know you're going into a meeting and you're going to be very critical of his teacher, maybe the student doesn't need to hear those critiques because it might interfere with their relationship. Or if you're planning on doing some sort of observations that you don't want the student to really be aware of while they're being observed, because that would skew the data, maybe you don't want them in the meeting to hear that they're about to be observed. You should have a representative from the school district, which is important because they're the ones that can really say yes or no to the money that you're going to spend in order to make some of these tests and services happen, especially if you need to hire people to help the kiddo. There should be a gen ed teacher, there should be a special ed teacher, there should be a diagnostician or someone who can interpret evaluations. And then as a parent, you have the right to invite whoever you'd like to the ARD meeting. Some people invite their family members, some people invite their pastor, I've seen that. Some people invite me. And you can invite whoever you want. They can't stop you in that. Next slide. So the IEP is a contract, and it's a contract between the parents and the school, and it decides how the child will be educated. There should be goals. There should be a placement. There should be a functional behavior assessment if there's going to be a behavior intervention plan. You don't want to have a behavior intervention plan and not have a functional behavior assessment, because then that behavior intervention plan is likely inappropriate because it's not based on data. Related services, transition services if you're age 14 and older, and then supplements such as the autism supplement or personal care supplements. Sometimes when you go to ARD, you want to ask for things that may not be in your regular list of things that you would ask for. Maybe your doctor has a suggestion, or your counselor has a suggestion, or someone out there has a suggestion that they think would help the child educationally. When these things happen, I like to follow the 5 golden rules. Submit a letter to the school district, and you can submit it before the ARD or after the ARD. If you submit it before the ARD meeting, at least the school has a bit more time to consider it. Sometimes if you catch them on the spot, it doesn't have the best result. So sometimes give them that information and let them consider it, and particularly allow the right people to consider it. So you want it to be dated on letterhead and signed by whatever professional is making the orders. You want to name the child's condition. You want to describe how the condition affects the child, describe what the child needs, and then you also want to say what the consequences will be if the child does not get what they need. That's pretty important. And you can submit this to your administrator, your principal. You could submit it to the DIA. You could submit it to your special ed director if things are not going well with your local ARD committee and you need someone above them to consider this new relevant information. Always send documentation to the appropriate person. If you send a doctor's letter to your classroom, your math teacher, she may not even know what to do with it. She might just shuffle it in some papers and it gets lost. It doesn't get to where it needs to go. She's not able to make decisions based on the documentation you gave. And so giving, say, a letter from the doctor to the math teacher, not only may it not get where you need to go, not only will the person that needs to see it and can make decisions about it not see it, but it also delays the process, even if it gets eventually where it needs to go. Always have proof that you sent your documentation. So that could be certified mail, it could be email, it could be sign and date my copy, take it up to the school. You have a copy for them, you have a copy for you, and you want them to sign and date it so you can prove it. What can you ask for at an ARD meeting? I like to say to my clients, you can ask for anything you'd like. And under the caveat that they may say no to whatever you like, but that doesn't mean you can't ask. Sometimes parents will say, well, I didn't know I could ask for that. And so you don't really know unless you ask. And maybe they can give it to you, maybe they can't. Maybe it's something that's not on the list of things, or maybe it is. You just don't know. So I always say ask. What can it hurt to ask? Some of the popular things to ask for are additional data. If, let's say your kiddo has some behaviors and nobody knows why, have we collected any data? Does anyone have any data to refer to? Or maybe the kid only has behavior in the morning. Have we collected any data in the morning? Have we collected data before it occurs, while it's occurring, after it's occurred? We can always get more data. I always think there's never enough data. There's always some piece of data that we could have more of. You can ask for an IEE or an independent education evaluation at an ARD meeting. You actually don't have to. You can ask for an IEE outside of ARD. It's not an ARD committee decision. So you can indicate during ARD that you want to request an IEE, and they can nod their heads. And then after ARD, you go and request it from somebody else. So there's that. You can always ask for additional evaluations. Maybe they did cognitive and achievement, but maybe you need a counseling evaluation. Ask for the counseling evaluation. If you need a functional behavior assessment because there are behaviors and you need an evaluation, you can ask for that. If you have a BIP, like I said earlier, and you don't have an FBA, it's probably not a good BIP. You can ask for a different placement if your child is being educated in life skills or in self-contained. You can ask for them to put your child in a less restrictive setting. You can ask, I do have some parents that have asked for more restrictive settings. You can always ask for a different placement. Related services like speech therapy, occupational therapy, physical therapy, counseling, those are all things that you can ask for. And then, or even like assistive technology, you can ask for those things. And if it requires an evaluation for that to be a yes, then they do the evaluation, unless for some reason they want to deny you evaluation, which is silly, by the way. I say that because they can't really actually deny you evaluation. If they deny you evaluation, they have to then explain why they denied you the evaluation. And you could always file for due process to request the evaluation and have the district explain to TEA, a hearing officer, why they declined your evaluation, which usually they don't want to bother with the hassle of paying for an attorney. So they just go ahead and say yes. Extended year services. Sometimes I get this question, especially early in the school year. ESY is based on regression recoupment data. We don't typically have that data until the end of the school year. So when parents ask for ESY before Christmas, the answer is probably going to be, we really need to wait until after spring break to know if they're going to qualify. And you can ask for compensatory education. If the school district has failed to provide a service, or if they failed to include your child when they should have been, because maybe they said on the IEP, this kid's going to gen ed the whole day and they never sent him to gen ed, then you can ask for compensatory education for them to make up for time lost. Independent education evaluations, they are available at the public expense to parents who disagree with an existing evaluation. So the first step is to disagree to your existing evaluation. The school district presents you with a, let's say, cognitive and achievement, and you disagree with it. You need to disagree to that evaluation in ARD. If you don't disagree to it in ARD, you need to revoke your agreement to it later on. You need to say, I disagree and I'd like an IEE, but at some point you need to disagree to that evaluation. You can request the IE after ARD. You don't have to do it during ARD. Sometimes you're getting evaluations in ARD for the first time, which I think is kind of awful. School districts should be giving you those evaluations before you ever go to ARD, so you have a chance to review them, not just like throwing them at you in ARD and you just have to react on the spot. Everyone likes time to think. So, you know, if after ARD you decide, I've read this thing, I don't like it, I don't agree with it, you can request an IE. But first you need to state to the school district in a written way that you disagree to the evaluation. And then when you request the IE, you also want to get the criteria for the evaluator that you're seeking. You must meet the agency criteria, that's qualifications of the examiner, location of the evaluation, etc. You can't just use anybody you want. They have to meet their criteria. The evaluation, when it comes back, must be considered by the ARD committee. And keep in mind that a private evaluation is not an IEE. So if you go to your doctor, you pay him $1,200 to do an evaluation, say for autism, it comes back, that's not going to count. That's not an IEE. That's a private evaluation, and they will address it under private evaluation rules. ARD meeting minutes. I never understand why it's such a hiccup. They make minutes. we should read them. You should include what you want in the minutes, and then we should type those, and we should all go home happy with minutes. But for some reason, that does not happen. Sometimes schools don't want to give you the minutes. Sometimes schools don't want to include your responses in the minutes. Sometimes schools just want to cut parts out of the minutes. I had a school that even refused to write the minutes. So fun times with those minutes. Anyway, everything that you ask for should end up in those meeting minutes, even if they're not somewhere on the IEP form. Make sure the minutes include the school's responses, positive or negative, any promises they make, who's responsible, and how long it's going to take them to do it. The worst thing is thinking you've been promised something in an ARD and coming out of that ARD and it's not anywhere in the ARD, in the IEP, it's not anywhere in the minutes. Review the minutes before you leave the meeting. That's usually the best way to catch anything. And if you get home after the meeting and you read the minutes and you go, oh my gosh, they left out this big important part, or they left out my request or anything, you can submit an addendum as a parent after the meeting if the minutes are incorrect or something is missing. All you have to do is type it up and say, send it to them and say, I would like this included in my minutes, and they have to attach it to the IEP. And always, of course, get a copy of everything for your records. What if they don't follow my IEP? If I only had a dime every time I was asked that in a given week, I might be a wealthy woman. It happens a lot. But there are methods of recourse that you have as a parent. You can file a TEA complaint, which is typically what we direct our parents to do. Filing a TEA complaint is easy. You go to the TEA website, there's a link, there's a form online, fill it out, click submit. You now filed your TEA complaint. As a parent, sorry, was there a question?
I think it was just somebody joining.
Okay. As a parent, it's really easy to file a TA complaint. They don't demand too much of you. As an advocate, or even our attorneys, they require quite a bit of evidence to prove our points. So if you're a parent and you suspect something is going on, or you think there's been a violation of your IEP, it's pretty easy to go to the website and submit the form. You can request mediation from TEA with the school district, which is hard to do by yourself without an attorney. However, that is something that you can do if they are not following your IEP consistently. You can request an ARD meeting to discuss why they aren't following your IEP. That does help put some things in writing. It also could mean that they decide to change whatever service you had previously gotten, and they're saying, well, we can't do that or don't want to do that, and they want to take it away now. So that could cause a disruption. It's always important to document every time you think there's been a violation of your IEP. It could mean that later on you have the ability to get compensatory education for those violations. Behaviors, probably something I work in a lot. I almost want to say all the time. I feel like everyone has behaviors. I'm sure I have behaviors. I'm sure you have behaviors. It's really not an uncommon phenomenon. I think it's strange that when a cat has a behavior, we all sit around trying to figure out what its tail's doing. What does that mean? Is it a happy tail? Is it a scared tail? And it's not anything threatening. But the second a human being has a behavior, it's a big kerfuffle. And it doesn't make any sense. Just like a cat is trying to communicate with you via tail, every human being is trying to communicate to you with behavior. Discipline. School personnel may decide on a case-by-case basis whether to attempt to change a placement of a child who has violated the student code of conduct. Students may be removed for up to 10 days for violating a code of conduct, oh, that's a lot, without an ARD meeting. So I often refer to these as the 10 free days that every school district gets every school year. They can suspend you for 10 days. They can send you to an AEP for 10 days. They can do whatever they want for 10 days. But once we get to 10 days, we have to have an MDR or a manifestation determination review and an ARD to talk about why this is happening and what we need to do to prevent it from happening. Once you're disciplined, the standard for services that must be provided to the student who's been removed from school is that the student must continue to participate in the general education curriculum or curriculum, although in another setting, and to make progress toward meeting the goals set out in the child's IEP. So just because you're placed in an AEP or some other disciplinary setting does not mean that all of a sudden your services stop. They do continue, and they have to still continue to educate the child. All students who are removed must get services that are designed to address the behavior violation so that it does not occur. Even if you go to manifestation determination review and they decide that your behavior is not disability related, they still need to address how we can prevent it from reoccurring in the future, typically with an FBA, a functional behavior assessment, and then doing a new behavior intervention plan. Manifestation determinations. The burden of proof is on the parent. There's not really much recourse for a bad manifestation determination review. There's not a reconvene. If you disagree at the end of the manifestation, you can, but there's not going to be, they're not going to have a reconvene. They're not going to come back and talk about it again. You can file TEA complaints about bad manifestation determination reviews, but that typically has more to do with procedure, although it can sometimes do with content. They no longer examine whether or not the IEP was appropriate. We talk about if the IEP was implemented, but we don't talk about if it was appropriate. The whole IEP team is not necessary. You just have to have relevant members. And then if the conduct was a direct result of the LEE's failure to implement the IEP, or was due or is caused by a direct or substantial relationship to disability, that will get you a manifestation determination. What they call a manifestation. I think the hard thing is sometimes as things are developing with kids, and because kids grow and do new things all the time. So sometimes we go to these MDRs and it's a behavior we've known about. And sometimes we go to these MDRs and it's behavior that, although it's disability related, we haven't known about. And sometimes because it was not previously known, the schools tend to not want to make it a manifest, even though it is clearly disability related. And there's a lot of things that you can make disability related. There's a lot of ways that you can try to look at what is going on with the kiddo, and and from their perspective of disability, kind of what caused them to perform an action that, even though maybe new or different, clearly is related to their disability. So if there's a manifestation, they have to conduct an FBA and implement a new BIP. They have to return the child to his or her previous placement, unless you guys decide in R to try something different. But if you were suspended 3 days and you used to be in gen ed, well, then after this manifestation determination, you go back to gen ed if it's a manifestation. The school may utilize a 45-day interim alternative education setting, or sometimes known as the AEP or DAP, for drugs, weapons, or serious bodily injury. So if you're meeting one of those categories, there's a chance you could do 45 days. If there is not a manifestation and the school says, which they often do, I think because they want to implement their consequences. But if there's not a manifestation, then the student will remain in the alternative placement until either an expedited hearing takes place or until the sentence is over. A parent may request a due process hearing, which we refer to as an expedited hearing typically. An expedited hearing must take place within 20 school days. And then the decision takes another 10 days. I think the hard thing sometimes is the schools know about this timeline for a hearing to argue the manifestation determination review and the disciplinary placement. So oftentimes what they'll do is they'll say, well, we're going to consequence them for 45 days or less. And if they consequence them for 45 days or less, there's no way that anyone can do anything, because by the time 45 days has gone by, even if you got requested an expedited hearing on day one, by the time you get to 45 days, the sentence is over. So it's not going to make a difference. So if you have a sentence that's over 45 days, you could go to an expedited hearing and get them out of that alternative setting. Anything less than 45 days, there's really nothing you can do about it. A school district may expel a student. That is possible. Restraint and seclusion. So these are some seclusion rooms. I do believe the one on the right is in Kentucky, and it looks like I think one of my parents described it as a walk-in closet recently. I thought that was an interesting descriptor, but it's basically a walk-in closet with a door on it, and it's locked with a window. The other one, I can't remember where it's located, but the thing, you can kind of see it. The kids have been drawing on it in chalk, and I think they wrote "Summer is here." So they've been in that room for a long time. There's a lot of school districts that utilize rooms just like this. Sometimes they have doors and they're locked and kids can't get out. And sometimes they'll just be like a room without a door. Sometimes they're padded, sometimes they're not. I think the worst one I ever saw was, it had a door, it was locked, there was a small window, it had a tile floor, and it had a drain in the bottom for fluids because they didn't let the kids go to the bathroom. And then there was also stains on the tile floor from kiddos who had injured themselves or gone to the bathroom in the room. Seclusion is placing a child in a special room or location and preventing the child from leaving by locking, blocking, or barring the exit. That also includes if the kid thinks that they're not allowed to leave or they can't leave even if they tried. So if you mentally put them in a space where they believe they cannot leave, then that counts. Seclusion is unlawful in Texas. However, proving that rooms are considered a seclusion room has been difficult in the court systems. Schools may use what they call a timeout space that is not locked and otherwise barred from exits. So when I think of a timeout space, I think of a beanbag in the corner of the classroom. Or I think of a desk with a partition on it, but not something where you could literally trap a child in a location. Restraint may be mechanical, physical, or chemical. Mechanical would be when they tie you to a chair or some other device or wall or whatnot, or maybe even tie you to yourself. Physical, holding arms, holding a kid on the ground, that sort of thing. And chemical is when they use a medication. Restraint may only be used when there is a threat of imminent, and that's an important word, imminent, serious physical harm to the student or others, or imminent serious property destruction. Serious property destruction is not throwing a pencil or breaking a pencil. Serious property destruction is not throwing a carrot across the room because you don't like your lunch. Serious, imminent serious physical harm is not the kid going, hey, I'm going to step on your foot, and then 5 minutes later he steps on your foot. That's not imminent. It's not serious physical harm. But oftentimes kiddos are restrained in situations that are not, where the threat is not imminent, and there is no serious physical harm, there's no serious property destruction. I have actually seen restraints occur over a kid throwing a carrot across the lunchroom. Or a kid breaking a pencil. That's not serious, it's not imminent, especially if, let's say, the kid breaks the pencil and then sits there for 5 minutes, and then you restrain them because they broke a pencil. Well, that wasn't imminent, you did it after the fact. Any kind of restraint after the fact, when it's not in the middle of happening, is not okay. A restraint is supposed to be an emergency measure. It is not a positive behavioral support. I know some schools want to put restraint and seclusion in their BIPs and pretend like these are positive behavior supports. They are not. They should never be in an IEP. They should never be in a behavior intervention plan. It's completely inappropriate for them to be there. I also should mention restraint. If your child is ever restrained, it is a failure of their IEP. The school district has failed. That child never should have been restrained. That child never should have been secluded. The second that happens, there is something wrong with your IEP. There is something wrong with the services and the people that are providing them. And you must come to ARD to correct that, because in a good IEP, there is never restraint or seclusion. SHARS. SHARS is when a school district can use a child's Medicaid to pay for services. When they do that, you typically sign the paperwork, and then you as the parent have the right to choose a service provider. And then, of course, Medicaid still requires medical necessity to provide services. So inclusion works, right? We all know that. So what's the problem? Why do we not have more of it? I found this quote that I thought to myself really kind of hits the nail on the head. If it's a priority, you'll find a way. If it isn't, you'll find an excuse. And I think every day schools find excuses not to include kids because it's not a priority for them. They want to do what's easier when it comes to inclusion, not what's appropriate, not what's good for the kid, not what's going to help. We all know inclusion works. We've seen inclusion work. We've seen kiddos grow leaps and bounds by being included with non-disabled peers. Yet, if it's not convenient for the teacher, if it's not convenient for the school, if it's not convenient for the administrator, if it's not a priority, then they find a way to get around that. I find when I show up to ARDS, all of a sudden it becomes a priority because they don't want litigation. So that tells you something. Placement is not dependent upon eligibility. All the kids with autism do not go to the autism unit. That's not a FAPE. That's not a free, appropriate public education. It's not least restrictive environment. And it certainly is not providing an individualized education plan if all the kids with one disability go to one place. The IEP must be implemented in the least restrictive environment, and that's based on the client's needs. So it's based on the IEP, it's based on everything, all their services, evaluations, everything to figure out what they need to be in the least restrictive setting. It should be as close to the child's home as possible. They can move you if you have a specialized program, like say you agree and you want to go to an autism unit and that autism unit is only provided on one campus, then they would go to that campus and they get to do that. There's no way to make them move the program to a different campus. But you should, typically speaking, be as close to your home as possible, preferably on your home campus. You have to think about where they would attend if they were not disabled. You want them to be on their home campus, in their neighborhood, with their peers, seeing the kids they've grown up with. You want that. That helps with inclusion. It helps it. And you want them to be with non-disabled children to the maximum extent possible. Even in a situation where a kiddo really needs to be, say, in a functional academic setting or a life skills setting, or maybe even an autism unit, if that really does serve them best, they should still spend the rest of their day doing specials, lunch, recess, or any of that kind of non-academic time with their non-disabled peers. Oh, my sad little PowerPoint. I guess it just decided to jumble the words. So tips on increasing the likelihood of a general education placement. It helps if you have few to no behavioral issues, preferably no behavioral issues. If you have a few, that's fine. We can typically work around those. Few to no personal care issues. If you have, let's say you're carrying a special medication on you, or let's say maybe you still wear a diaper, that's not a reason to not include a kid. Those are small things. Those are things that can happen, maybe a trip to the nurse once a day or something of that nature. But the more complexity you have, the more that it requires when it comes to personal care issues, the less likely you are to get into gen ed. Progress must be made on academics and goals. You can be on a modified curriculum and be in gen ed. That's possible. Then you're just making progress on a little bit different academics and goals, but you can still, as long as you can still make progress, right? That's what matters. And then, of course, the question of priority. Will the staff make time? And that's sometimes what you really are arguing in an ARD meeting when you want your kid included, is that the staff, that when they go to gen ed, the staff will be able to meet their needs and meet the needs of the other 30 children that they want to claim, and that everybody will be fine. Everyone has to be willing to make time for your kid. And that's sadly kind of what it boils down to often. Transition planning begins at age 14. You can attend until your 22nd birthday, and it must reflect the future wants of the student. Also, person-centered planning, which is something I think school districts are kind of getting away from. They don't want to do it as much anymore. But you can ask for a person-centered plan. You can ask for a person-centered evaluation. Those are things that you can ask for, where they look at the individual needs and wants of the student, no matter what their disability is. To agree or to disagree? What does this word "no" you speak of? Exactly. So if you agree, services can be provided within 5 days or immediately, depending on parent preference. You can waive your 5 days. And when you disagree, you open the window for complaint resolution. So maybe disagreement means you're filing for mediation or you're filing a due process. At the very least, you should be going to a reconvene, which should occur within 10 days. To discuss your disagreement and go over the issues that you disagreed on. And then if it's not resolved there, you have your window open for more complaint resolution, such as a hearing or a mediation or a resolution session. The reconvene occurs up to 10 days after you in a disagreement. The parents, you as parents, have the opportunity to state your concerns in writing prior to the reconvene, so we all know why we're going there. I think that's helpful. I think they need to see what you're disagreeing to. Sometimes you get in these meetings, things get a little heated and no one really knows what everybody's fighting about. If you put it in writing and say, here's what I'm wanting, then they can look at it, their administration can look at it and decide if this is really worth them fighting over. You review the point of disagreement, and of course, it continues if you still continue to disagree. Sometimes parents will get confused when it comes to, they'll disagree at the ARD committee, they'll disagree at the reconvene, and then they're surprised when 5 days later their IEP goes into effect. If you don't use anything to resolve the disagreement, if you don't go to mediation, if you don't do a due process hearing, that IEP that you disagree to will go into effect within 5 days. There is a 2-year statute of limitations on any issue. I think we always talk about mediation and TA complaints and due process and all of that. Oftentimes parents lose. That's a very real thing. And I think sometimes parents don't know that, and they really think, it's hurtful. It really is hurtful when you know you're doing the best for your kid and you still lose. So oftentimes parents lose. There's no immediate satisfaction, or sometimes there's no satisfaction. These things can take months, if not years, to resolve themselves. So you really have to ask yourself as a parent before you go into one of these, a hearing or a complaint process or even a mediation, is this really what you want to do? Do you really want to fight them on these issues? I personally have raised 3 children with special needs, and I know from very personal experience, it's hard to listen to hard news. It's hard when you get an evaluation and it doesn't come back. It comes back with something maybe you were unaware of when it comes to your child, or you didn't know, but once they tell you, then you know. Sometimes it's hard to understand the information available, especially when you're emotionally invested and you love your children. I think some of the most helpful things you can do is to bring someone with you to ARD, whether it's a friend or a pastor or a relative, or even an advocate or attorney, to help you make informed decisions, because we do love our children, and our emotions are involved, and sometimes it's hard to separate out those emotions. Enlisting a support person, very important. I like some of these because, this really is how sometimes it goes in ARD, right? There's all of them on one side of the table, and then there's you. I mean, the odds are kind of stacked against you. So sometimes it's good to have an extra person on your side. And I am willing to take any questions that you guys have. Of course, Disability Rights Texas, we do take cases for special education. We have priorities that we look at, usually behavioral issues, inclusion, child find, restraint seclusion, that sort of thing. We do have intakes that we can do online. You don't have to call and talk to anybody. You can just fill out the form online, much like a TEA complaint. No, not really, but it's probably a bit more thorough than a TEA complaint, actually, if that's not something. And you, of course, can call us, speak to our education lady. Her name is Nancy, and do an intake that way. But we're always happy to hear your complaints and questions and help you where we can. Does anyone have any questions for me?
I know I do. I will see if other people have any questions, but I can ask you mine in the meantime. So
Okay.
I know that something that gets brought to my attention frequently is turnover in the classroom. So whether it be you know, the special education teacher themselves or the aides or whoever it may be, what is the best way of handling that? Let's say that all of a sudden there's a long-term sub and, you know, they're not hiring a new teacher. So then that kind of leads to a stacked on problem on problem on problem. Do you have any advice or just kind of insight into what to do in a situation like that?
I think personnel issues are some of the hardest. One, because as parents, advocates, and attorneys, we have no we have no wiggle room. Like we don't, that's the school district's purview. They get to decide. They get to decide who they hire. They get to decide who they put in that spot. They get to decide who they fire. I mean, all those things they're their purview. We get no say so in those things. And sometimes it very much affects a kiddo who, whether they have need of a staff member that they cannot seem to fill, or in the past several years we've been dealing with shortages, where some kids just aren't even getting their IEPs done because there's not enough teachers there to do them. I have some friends that work on education and on the education side, and one of the things they've said to me through these shortages is that really the squeaky wheel does actually get the grease on this one. If you think your IEP is not being followed, complain, because they're going to then all of a sudden focus those few resources they have on you to get you to be quiet. I know that doesn't fix it for all the kids, but it might make them go, maybe we need to put more focus and put a bit more energy in hiring. But the reality is sometimes there's just not people to hire, especially when you're a paraprofessional aide and they pay you nothing. And they the bar is really low on how much education you have, so you may not even get a decent one. It's just a warm body. But yeah, it's difficult.
Okay. Yeah. And then you mentioned like an autism eval. I know I get parents who call and they ask, you know, what's the process? And I've heard a lot where they're going to go to like a specialist or a doctor, you know, somebody outside the school district. So if a parent wants an eval for autism, do they just request that with the school?
Right. If you want an educational autism evaluation, request it from the school. If you do it in writing, they have to respond to you within 10 days. If you go through your private doctor, it's going to be counted as a private evaluation, and they can just kind of toss those, which means you're wasting your money.
Okay. Okay, perfect. And then one more question I had. So you mentioned about the minutes and there being problems with that. Would you recommend, if the school is being difficult with minutes or anything, to have the parent type their own minutes in the meeting? Would that be appropriate? Would that be a good form of having minutes on hand?
Absolutely. If your school won't write the minutes, won't include what you have to say, write your own minutes and tell them to add it as an addendum to the IEP. You have a right to have your voice heard. Parent participation is guaranteed under federal law. There is no reason that you can't do that.
Okay, cool. Okay, perfect. All right. Does anybody else have any questions about special education process or anything that Kendra spoke about today?
I'll ask a question. Thank you, Kendra. This was very informative. So I have a kindergartner, and written in his IEP is that he gets 15 minutes of inclusion teacher time. And right now, the inclusion teacher is actually with him for an hour every day. And so I've called an ARD to try to get that written into his IEP. I just thought I would get your thoughts on what do we do if they say no? And my anticipation is his teacher actually told me he's getting an hour right now, but as they do evaluations, they might try to move her somewhere else. So that's why I called the ARD to try to get it in his IEP now before other children need that time. Does that question make sense? So, what do we do if they say no, I guess?
I can kind of see that going both ways. So on one way, I always tell the school district if they're doing something that's not documented to give themselves credit. You want to give yourself credit for any kind of services that you're providing, but maybe you didn't put it in writing or didn't put it in the IEP. On the flip side of that, if it's not in your IEP, they don't have to provide it, right? And then on the other kind of dark side of that is if they start providing too much and they start wondering if maybe you need a change of placement because your least restrictive environment doesn't look like it's this one, like maybe you need a more restrictive setting because you need more services. That can also be a thing. So it's definitely a delicate balance to play, to know.
Yeah.
And it sounds to me like your teacher's trying to warn you of a possible placement change. So
Yeah, I hope not. It was a conversation yesterday, talking about how he's doing behaviorally and also academically. And behaviorally, we're working through some things and he's doing pretty well. And that was originally, we wrote the inclusion teacher time into his IEP to help him with behaviors like transitions and can he stay in line, things like that. But I don't think he needs her for that. I think he needs her for academics.
I think it's a lot easier to get a placement change to a more restrictive setting when you have academic issues than it is when you have behavioral issues. Behavioral issues, we can try all kinds of things. We can try a whole lot of things before we give up and put them in a more restrictive setting. Academic issues are one of those things that will get you put in a more restrictive setting much quicker.
So because right now I still believe that his academic setting is appropriate and we're working with his teacher to adapt his work, do things like highlighting. So the worksheets are not so complex for him. So how would I approach the meeting to protect his placement while also trying to secure that inclusion teacher time for him?
It's hard to know because I don't know what school district you're in or the particular politics of your campus. And
Yeah.
I think that's kind of where we kind of run into what's that school's priority. Do they want to, keep the kiddo in there and watch him make progress? And are they willing to work with you? Or are they just wanting to kind of get rid of him and put him somewhere else where he's someone else's problem, right?
I don't think his teacher is giving up. She is not giving up on him, and I appreciate that.
That's
so
good.
Our conversation yesterday was it was initiated by me because the worksheets he was bringing home were terrible. And so she was not coming to me saying, I can't teach your kid. But she did say, I think he needs the inclusion teacher time right now. And by the way, it might go away at any moment.
Okay.
So, okay. Sorry. I know I brought a specific question, but
no, you're fine. No, you're fine. I mean, it happens. But like I said, it's a delicate balance sometimes to know, like what your campus, none of us are psychic, right? So, but I mean, you always have to know your players. You have to know kind of what they're up to. You have to know what you're up against. Having that teacher give you tips and hints is actually really useful. Use those to your advantage when you get to ARD.
Okay. Thank you. And if there's time, I might ask you one more question.
Okay.
It's not super specific. Some friends and I that also other parents of children with Down syndrome are struggling with whether or not OHI is if Down syndrome equals OHI legally, or if that's just up to the school district to decide if they will accept Down syndrome as OHI and not require IQ testing.
They should always do IQ testing. If they're not doing IQ testing, they're really kind of doing a disservice to your child, because there's so much information we get from cognitive and achievement evaluations that we need. I would think particularly with Down syndrome. So yeah, if they're not doing that evaluation, I would be concerned regardless of the label. OHI usually is used for ADHD or some kind of other health impairment. I guess that's why they call it OHI, right? But anyway, the OHI is a form that your doctor signs. So the school district doesn't get a lot of say so on that. It's really the doctor that says, are you meeting these criteria? And then they send that off to the school, and the school has to say, well, the doctor says yes, so we say yes. But if they're not doing cognitive and achievement evaluations, I would be concerned. I would be heavily concerned because they're not getting a full picture of your kiddo.
Okay, thanks.
All right, are there any other questions? No? Okay. Okay, well, Kendra, thank you so much for doing this presentation today. I know it was very informative for me, and I mean, right now my son is 2, so he's not in the school process yet, but I know we get a lot of questions, and I like to have a better knowledge of, you know, the process of special education and kind of what advice I can get or give, or, you know, how to help. So, and it's nice to know that Disability Rights to Texas can help with that as well. So yeah.
Well, you are more than welcome. If you guys have questions, you can email me and I'm happy to answer if I can. If I think like you have an issue that like probably needs an intake, I'll send you to intake. No big deal. Yeah,
Okay.
ask away.
Awesome. Well, I appreciate that. Thank you so much for your time and your knowledge today.
You are more than welcome.
Awesome. Well, I will be in touch. Thank you.
Okay.
Bye-bye.